Hey everybody, I'm attorney Mike Contant. Did you know there's a way to overturn your old drunk driving conviction? So if you had a drunk driving offense between June of 2011 and April 17, 2019, and you took the breathalyzer, and that was a significant factor in your decision to take a plea or the jury in finding you guilty, or the judge or jury in finding you guilty at trial, you have the ability to get that overturned. Now let me tell you why. A couple of years ago, in Massachusetts, there was this litigation called the Annanias litigation, and it challenged the admissibility of the breathalyzer test. Did it on a couple different grounds. The first was the scientific reliability of the machine. The second was the way the machines were being calibrated and certified by the Office of Alcohol Testing. Unfortunately, the judge found the machines were scientifically reliable. However, during the litigation, it came out that the way the machines were being calibrated and certified, as well as the way the Office of Alcohol Testing was maintaining their records and providing them in response to requests for information for cases going to trial, was suspect. So therefore, the judge made a ruling that for any breathalyzer tests during, again, the period of June 2011 through April 17, 2019, that those should not be admitted as evidence at trial. Now you might ask, well, June 2011 is a long time ago. If I took the test back then, my case is long over. If I was found guilty, I've probably done my probation, everything's all over with. Why would I want to challenge that now? And the reason is because of Melanie's Law. Melanie's Law since 2005 made it so that any drunk driving offense you have, any conviction, is cumulative. In other words, it's a lifetime look back period. So that even if it was a first offense, if you were to ever, even 20 years from now, pick up another drunk driving offense, it becomes a second offense, or a third offense, or a fourth offense as it goes on, with much harsher penalties as you go on. So what this litigation did was it said for this period of time, breathalyzer test should not have been admitted. And so if it was a significant factor in your decision to take a plea, to take some sort of probation or anything else, or if it affected the jury, significantly affected the jury or judge in finding you guilty at trial, and an example of this might be that, it's really high breathalyzer test. Maybe it was like a 0.20 or a 0.15, significantly over the legal limit. And there wasn't a lot of other evidence to show that you had done it. So maybe you didn't do the field sobriety test, or maybe you did them, but you didn't do that badly on them. In cases like this, it is possible to show to the judge that you in fact was a significant factor, the breathalyzer test was a significant factor in your decision or the jury's decision in finding you guilty. So a motion for new trial can be filed on your behalf, taking this into account. And in many of these cases, because of their age and other factors, they're not even being retried. Many of these cases are just being dismissed. In late February of 2020, it was widely publicized that the registry was going to have to send out more than 27,000 letters to people who were in this exact same situation. And regardless of whether you received a letter or not, if you meet these criteria, you may be subject to having your drunk driving conviction overturned and getting a new trial. So you may have got the letter, you may not have got the letter. If you meet these criteria, again, breathalyzer test in Massachusetts between June 2011 and April 17, 2019, and it was a significant factor in either the judge or jury's decision to find you guilty or your decision to take a plea, you may have the ability to get that drunk driving conviction, or even if it was just a quaff, if it wasn't a conviction, overturned, and get a new trial, possibly get the case dismissed. So if you have any questions about this, about drunk driving, traffic offenses, or anything like that, please feel free to shoot me an email or give me a call. I'd be happy to speak with you about it.